Alex here with the Legal Nuts and Bolts video on witnesses. In this video, I wanted to get into the meat of the issue. I kind of danced around it in the past with some of my previous videos. For example, I did a video on subpoena where I just talked about like the procedure for how to have a subpoena issued and serve it and all that. And I've kind of talked about some of my previous endeavors in my court case, my child custody case specifically, where witnesses were involved. But I didn't really talk about what you should think about as a viewer in your own case when it comes to figuring out the best witnesses, if you can even get any witnesses, and how to go about doing it. So I have 7 main points that I wanted to go over. The first one is pay attention to the type of hearing that is coming up. And some people will even like ask a witness to come to court and they don't even have a hearing yet. So if there isn't even a hearing, I mean, just there's no reason to be talking to witnesses about coming to court. You don't even have a date yet. You don't even know if you're going to get a court date. So first off, make sure you have a hearing. Second off, make sure it's either an evidentiary hearing or a trial. There's all kinds of hearings, like hearings on law and motion, hearings like case management conferences, settlement conferences. Those types of hearings, witnesses don't testify at. The court isn't going to take evidence and make like findings of fact and conclusions of law on it. The court will make like at a discovery hearing, the court will make like a ruling, but it won't be based on anything a witness is saying. It's going to be like, the types of discovery instruments you guys can use and when they're due by and all kinds of stuff like that. At a case management conference, the court's going to set dates like, when your trial is going to be, when your settlement conference is going to be. So like at these hearings, you shouldn't be bringing a witness. If you do, the court probably won't even let him say anything because it's just not, that's not the right, that's not where the witness should be going to testify and provide evidence to the court. So just make sure it's an evidentiary hearing. So you've already basically had your motion considered and the court has agreed there needs to be an evidentiary hearing. Make sure it's that hearing. Or if you haven't had your trial yet, most people settle and then they're in like for example in child custody, a lot of the stuff is post-judgment. So you have all these hearings after your case is settled, or in the rare case you've gone to trial, you have more hearings. But if you haven't settled and you haven't been to trial yet, you're going to get a trial, and that's of course where your witnesses should be. That's where you should get your witnesses too, so that they can testify. The second thing is the value of the witness matters. The closer the witness is to you, the less good they can do. They can still do quite a bit of harm, but they can't do quite as much good. I mentioned in a previous video, please watch it. I think the title is Spouse Testifying, and I cover like your wife or your girlfriend or your boyfriend or whatever, mom, dad coming to court and testifying. I didn't necessarily say you shouldn't do it, but I covered a lot of the caveats, the drawbacks, and the risks that you take when you have somebody really close come to court and testify for you. It's just not as, it doesn't look as good as if you got, for example, a teacher or like a dentist or a doctor or a psychologist, somebody that's not a friend or a family member. Those are the best witnesses to get for, to come to court. Also, level-headed witnesses are good. When you get a witness to come to court, if you're questioning your own witness that you've subpoenaed to appear, you can't ask them like leading questions. So if it's just a scatterbrained person, if they're not good with details, those are things to consider because they may just not have the best answers in the courtroom. They may forget things. They may not care. So that's another thing to keep in mind. Make sure the witnesses aren't hostile, and this is so hard to deal with because a lot of witnesses, even if they see your child being abused or neglected, they just don't want to go to court. And if you ask them the wrong way, they're just going to get mad at you. And it's sad to say, but a lot of witnesses care more about their anxiety in a courtroom than they do about the welfare of children, and they'll take it out on you. I mean, if you just say, you know what, I'm just going to subpoena you and you better go or I'm going to throw you in jail, you may get them to go to court, but they may, want to sabotage your case. Even if it's not like a blatant lie, they may just not want to really bring up some of the most important details that the court needs to hear. They may just leave things out or say them in a light that's not most truthful. So try to avoid forcing a witness to go to court, and if you do, try not to just be a jerk about it. I mean, present yourself as somebody who's really just, desperate, and, you're sorry that you have to do this, but you have to. A lot of times, if it's like a police officer, a doctor, or some kind of professional, they won't like you, but they won't want to disobey the subpoena. If it's just some like random person, sometimes they just won't go to court, and I'll go into that at the seventh issue. So I'm going to move on to the third issue. Make sure the witness is needed. It sounds obvious, but a lot of people make a huge mistake on this. So, for example, if you file a motion saying that you want to modify custody because your ex isn't taking your kid to school, she's had 8 absences. Well, if your ex responds on opposition, I have, yeah, I was absent 8 times because I had like a severe illness and I couldn't take the child to school. Well, don't bring people from the school to testify that your kid was absent, because they actually admitted in their opposition. What they have provided the court is with an excuse. If you have witnesses that can refute that excuse, bring those witnesses. Don't pay attention to when you can avoid bringing a witness. So that was one example, which is where your ex files in their opposition in admission to what you needed the witness to testify. Another one is make sure that the witness is legally relevant. So, for example, somebody will file like a restraining order, or in Nevada it's called an ex parte motion for like a temporary protective order. We call them protective orders, and then you get served this ex parte order saying you have to stay away from them a certain number of feet and all that, and then you think, oh, I'm going to bring like these witnesses to show how good of a parent I am, or these witnesses to show like that I'm a good person. The court is going to analyze certain legal things at that hearing, and one of them is there a threat of domestic violence, and the other one is, has domestic violence actually occurred? So if you're bringing people to come in and say how good of a parent you are, that's not relevant. So you're wasting the witness's time. If you have people that say you're a good parent, that's useless. You're there for a protective order. You're not there for child custody issues. If you're if you have like people that are saying you're a good person, that's not going to go anywhere. How does that help the legal standard? I mean, if they actually witness some kind of violence and your ex was the one that started it, now that's a good witness, because they're going to be going into court and saying, yeah, there was violence, but she's the one that was starting it, or whatnot. So just make sure. Another case would be, maybe you got an evidentiary hearing on a child support motion. That's not the time to bring in witnesses to talk about how good of a person you are, or any kind of child custody issues that you're having, or any neglect. That's the time that you might want to bring a witness, like maybe bring an employer, because your ex is saying you're willfully underemployed, and your employer can go in and testify and say, you know what, I had to reduce his hours because of the economy. He's not purposefully reducing his hours, I had to. That's a relevant witness for a child support issue. So make sure the witness is needed. The fourth issue is get the affidavit first. So this is not always possible, but I was able to get affidavits a lot. There was 2 ways that I would do it. The first way is I would feel out the provider, and I would calculate, is this a person who's going to be willing to do an affidavit? Like, for example, I was able to get one from a neighbor who saw my ex peeking through my windows while I was on vacation. I just asked him, can you do an affidavit? He said yes, he did it. Another one was the dental hygienist and my dentist, because of the severe tooth decay that my son was suffering. I just asked him outright. They said, yeah, they'll do the affidavit. Sometimes I'll subpoena them first, and then I'll tell them, I know that the subpoena says you have to come to court, but if you could just do this affidavit, there's a good chance that my opponent will just admit these things, and then I'll be able to excuse you from coming to court. And I was able to get affidavits from people that were reluctant when I approached it that way. So that one, for example, would be the teacher at the school and the attendance keeper at the school. And both of them didn't want to go to court, but I subpoenaed them. And once they were subpoenaed, they realized they had to go. And that's when I said, why don't you just do an affidavit? Maybe that will cause my ex to just admit these things, and then you won't have to go to court. And that actually that actually worked for the attendance, because my ex ended up admitting once a lot of times this happens. You don't think it will, but it does. You allege something in your motion, and you put an affidavit from some kind of provider, or like I mentioned with the attendance. I put in a copy of the attendance sheet showing the absences, and I put an affidavit from the attendance keeper. And on opposition, your ex won't deny it. I mean, they could try that, but it's going to really piss the judge off if they deny that they were absent, and then you get the attendance keeper to come to the courtroom and testify. I mean, that person's not my friend or my family member. The judge is going to believe her, and then they're going to get pissed off at your ex for lying. So a lot of times they'll just admit it. They'll just say in their opposition, you know what? Yeah, I was absent. And they'll come up with some excuse. Our son was sick all those times. Well, now you don't need the attendance witness. Just excuse them. You don't need him. They admitted it. Now what I need is, I got the dentist actually in this case. And one of the things my ex said was that when our son didn't show up to school right after the surgery, it was because he was in pain. And the dentist was able to testify that kids are not in pain after this particular surgery. He should have been able to go to school. And she was an expert witness. So that was an example of where, okay, she's admitted the absences. Let's shift gears. Let's use this witness to refute her excuse. So just that's one of the things you have to focus on, because a lot of times self-represented parties, they look like they're just out to annoy and harass everyone. And or they're incompetent. So either they're not subpoenaing anyone, and then they come to court with all this paperwork that's all hearsay, and it's not admitted into evidence. So for example, if I went to court with the attendance sheet, that's hearsay. I need a witness to say, yeah, this is in our computer system. This means this many absences. Obviously, just any old random person can look at that sheet and they'll probably believe you, but the whole reason why people bring witnesses to court is so that you can cross-examine them. If I come to court with a piece of paper, it's not fair to my opponent because they can't cross-examine that piece of paper. If I come to court with a police report and the police officer's there, they can cross-examine that police officer as to what he put in that report. Maybe some details were left out, maybe some dates and times, or, you can address these issues. If you just come to court with a police report only, and I mentioned this also in a previous video, it's not fair to the other person because all they have is that police report to try and refute. Now, again, I'm not going to rehash some of these issues that I've covered in previous videos, so make sure that you look at the other videos, the one on subpoenas, the one on spouse testifying, and I think there's another two that cover some of these details. I'm just going to move on. I want to just get the point across that you need to make sure your witness is needed, and that you need to try to get that affidavit first. The other thing that I was able to do sometimes was I was able to make a witness not needed later on because of a hearing. So sometimes I would file a motion, I would get the affidavit, and then my ex would oppose that, or she would not talk about it. She would address some issues and then skip over the one where I had the witness. Well, sometimes you'll get a hearing before your evidentiary hearing. They call it like an appearance hearing, or they'll call it like a hearing on law and motion, where you just talk about whether you are even entitled to get an evidentiary hearing. There were some times that at those hearings, I was able to say, you know what, Your Honor, this witness here is really only needing to testify about this small thing. I really think it would save the court and the witness a lot of time for my ex to just go ahead and admit that, because, I mean, this happened. And it works. I mean, especially when it's a small little issue. The court's going to look right at her, and she's either going to double down and lie, and then the witness is going to show up in court and testify against her, or she's going to think, you know what, I'm just going to admit that and say I had some kind of excuse. And once that happens, you can excuse that witness. And a lot of times the excuse isn't the excuse doesn't excuse the situation. I mean, it's more like a desperate reaction from them. They didn't think you were going to get a witness, and now you have one, and now, oh, they're panicking. And so they'll just admit it and try to minimize what they've done. But anyway, the point here is you're moving forward in your case, things are being proven in your case, and you're excusing witnesses because you don't need them. It might feel good, especially if you're just getting into like year 1 or 2 of your child custody case, to just haul all these people into court and like have them say all these horrible things about your exes. But it's always better to use the witnesses as a last resort. It's not the first instinct of someone representing themselves to think from the perspective of, how can I excuse this person without waiving issues that I'm trying to bring up to the court. So I mean, don't just excuse people to be nice and then lose your proof. If your ex won't admit to the things and you need the witness, you just have to get him to come to court. But don't necessarily just kind of bury your head in the sand and not pay attention to those little details, like the one where I mentioned you have a great witness and they're going to testify. Again, I'm going to go back to the absences. They're going to testify regarding absences, and you're all stoked because you have them dead to rights on 10 absences, and then your ex admits them. Don't keep going, oh, you know what, I'm going to still bring you to court and testify. There's no reason for it. You know, and if it comes up in court, if your opponent says, hey, he didn't bring the witness, that's when you go, hey, look, in their opposition, they admitted right here. And because they admitted that, I didn't bring the witness because I don't need to. And the court has to recognize that. That's the whole point of filing briefs before you go to a hearing. People are so used to the Judge Judy style court stuff that they see on TV, where people just show up and then they just talk and then just wing it. In a formal court case, there's a point to all these things that people are doing. You know, the research helps the judge understand what law is controlling. And also, as I mentioned, some of the details in those briefs will indicate what witnesses aren't even needed, what things have been admitted to. So otherwise, it's a complete guessing game, and you could end up bringing in 10 people and end up wasting 9 of their time because, you know, your ex finds out you're bringing all these witnesses and they just decide to admit to a bunch of things. I mean, that's just how it goes, and when it happens, you need to let that witness go, keep going with your case, and focus on using other witnesses in different ways. For example, as I mentioned, sometimes they'll admit to an issue, close that out, let the witness go, but their excuse now brings to relevance another witness who might testify. Pointing, I think issue number 5 was pointing out an admission or trying to get an admission. So I actually just covered that. I kind of blurted into the affidavits issue, which was point 4. By the way, I'm going to do a separate video on affidavits alone. That'll be my next video, so I'll get you some details on what exactly they are and how they work later. The 6th issue is how to talk to a witness once they're going to appear in court. First of all, don't put them in a pressure cooker. Don't tell them everything is riding on this. I need you. Most witnesses are scared of court and they don't want to go. So the last thing you want to do is put a bunch of pressure on them, especially if it's your own family and friends. And sometimes those are the people that get the most pressure because it's like you feel maybe more entitled to expect more of them. But seriously, especially a spouse or a girlfriend or a boyfriend, do not put these, it's going to make them resent you. It's going to make them bitter about all your court stuff. You're going to be, if you end up breaking up, you're going to be that ex that made them not want to get with someone who has kids because they're going to just remember how they had to go to court and you just like made them feel bad for not saying something right. Or don't put them in a pressure cooker. I recommend not coaching them. I've never coached my witnesses. I feel like one of the strongest things you can say at the very end is, have I talked to you about what I was going to ask you? No. Have I coached you on what to say? No. So everything you're saying here is organic. Yeah. And that makes it look more honest. And it also, again, it's less pressure on them. They can just speak naturally. If they don't get something right, you can just ask the question in a different way. If they say something that doesn't sound good on cross-opposition, on cross-examination, then you can cross and address that issue and kind of close it up. I don't have any good examples of what I mean there, but if I get another example, maybe I'll put it down in the comments, but just let them speak freely. The other thing, with child custody cases specifically, I always would assure them, no one's going to ask you who's a better mom or dad. None of my witnesses were there to do a custody evaluation. That's the exception. If you have a custody evaluator, they're paid to do that. Let them do their job. But when it comes to teachers, principals, hygienists, doctors, dentists, these people aren't coming to court to say, yeah, he's the better parent, he's a good dad. And that's one of the fears that they have. They're like, oh my God, I'm going to court for some kind of custody dispute or some divorce. Oh, I'm going to have to say am I going to have to say who's better? Am I going to steal someone's kid and give them to someone else? It's like, these are terrifying things. So the first thing I would say is nobody's going to ask you these things. all that you have to say is a few statements regarding certain facts. And so I would, for the dentist, I mean, the questions are going to be about the x-rays, the tooth decay, and things along those lines. No one's going to ask you who's a better parent. The court will decide that, and it will apply some of the facts that you support with your testimony to that decision. But that's not going to be your call. That's the judge's call, and it kind of would put them at ease. So, I mean, it's really an art on how to get witnesses to appear and prepare affidavits for you. You just have to have really good people skills. You have to be, you can't be awkward, you can't be weird, you can't be scary. You're not going to get any witnesses. They're just going to be scared of you, or they're going to be nervous. They're going to think you're weird. So the more people skills you have, the better. It's so easy for lawyers to get witnesses because the witness knows this person's a professional, they've gone to school. When you're trying to get a witness and you're representing yourself, a lot of witnesses are weirded out. They're like, you're not a lawyer. That sounds weird. You can make me go to court? So you kind of have to show an even better and even more level-headed personality than an attorney, because you're too close to your case. You don't have the schooling, and it just makes things look really shady and questionable to some people. So I would always try to make it as small of a deal as possible. I would try to act like, try to act like you're doing everything in your power to get them excused. That was a huge thing for me. At every turn, every declaration and affidavit, every witness, I always made it apparent to them that I was going to do everything I could to get them excused from going to court, and it gets them on your side. So it's if they really believe that you're trying to do that, they will do an affidavit. They will state the details in that declaration, and when your opponent sees those, so a lot of times it'll scare them into backing off from whatever kind of BS story they had, and just playing it safe, admitting that, and then there you go. You can excuse your witness now. So the seventh issue is get the subpoena. I don't care how much of a friend they are. I don't care if it's your wife. Just play it safe and get the subpoena, because if you don't get the subpoena and something happens and they don't show up in court, the first thing your opponent's attorney is going to say is, well, maybe they listed them on the witness list, Your Honor, but they didn't subpoena them. So obviously they didn't want to come to court, and they weren't bound to go. So next thing you know, the judge is agreeing you now can't bring your witness. The court's going to move on with the hearing, and if it goes to an appeal, what are you going to say? I couldn't win my case because my witness didn't show up and the court wouldn't make them show up. Your opponent's going to say, yeah, they didn't subpoena them, so that was their fault. So even if you have a friend, even if you have a wife, some lawyers might not agree with this, but in my opinion, it was just the safest bet to get that subpoena filed and served, because if anything goes wrong, you can say, you know what, Your Honor, they're a good friend. Something must have gone wrong. Maybe their car broke down. This issue is too important to proceed on. And your opponent can raise a big stink about it all they want, but as long as that subpoena is on file, you have the power to say, I want them to be hauled into court. And a lot of times they won't be hauled into court. A lot of times the court will try to work around it. So like maybe you've gone to court on 5 issues and your witness is only relevant to one of those issues. The court might say, you know what, let's hear these other 4 issues. Maybe I'll rule in favor of them anyway. And if I do, we can just say that that witness was moot. Sure, the teachers didn't show up, but the dentist showed up, and the testimony from the dentist is enough for me to modify custody. So we don't need the teacher now because I've decided I already have enough with the dentist. Sometimes they'll say, you know what, are you really refuting these things? And sometimes your opponent will kind of think, oh, maybe I don't know. Okay, I'll just, you know what, let's just go ahead and say that happened. I'm gonna, use this defense instead. So as a last resort, they might order to show cause the witness, and I know that in criminal cases it's much more serious when people don't show up. I mean, I've heard of them in some counties. right then and there sending a deputy out to find him, track him down at work, at home, and bring him straight to the courtroom. I've heard of these stories. I don't know if this is something that they would do in like a child custody case. It might be something where they just continue the hearing and until the witness is arrested and brought in, or until a witness comes in on their order to show cause, to show the court what excuse they had for not coming to court. But anyway, the subpoena, it basically preserves your right to have that subpoena, to have that witness come to court and testify on the issue that you brought to the court's attention. If the witness, there's some really weird cases where, like, if your witness dies or something, I don't know how these edge cases work. My understanding is that sometimes you can use a statement or a letter or an affidavit in weird cases like that, where a witness is dying or dead, or I don't know, they've been incapacitated in some way, and you just really don't have any opportunity or any method of actually questioning them anyway. So the court will just say, you know what, since this witness is not going to ever be able to testify, I'm going to go ahead and allow this evidence, which is normal, this exhibit, which would normally be hearsay, into evidence, and we're just going to have to go with that. Anyway, those were the main 7 issues. I'm going to just go over them one more time. Make sure the hearing is the right type of hearing. Make sure the witness has some value. Make sure the witness is needed. Get the affidavit first. Oh, by the way, if you can't get the affidavit and put it in your motion or on file, at least bring it up in your motion that you tried. So state that, you know, this witness is crucial to the case. I tried to get an affidavit and they refused on this day. I know it's risky, but I want this witness, you know, this witness is going to be subpoenaed. I'm going to compel their appearance. And anyway, make sure you try to point out any admissions, or if possible, try to get some admissions so that you can excuse that witness. Make sure you talk to them respectfully. Don't put them in a pressure cooker. And then, of course, make sure you get that subpoena issued, served, and filed. With that, if you have any questions, put them in the comments below. Really, this is like one of those things that you just have to be quick on your feet and think from other people, put yourself in other people's shoes, and be really open-minded, because luckily I've never had a witness not show up in court, but I can't imagine how scary that would be to have so much writing on your case and then your witness not show up. And in my case, all of them showed up, thankfully. So just, you know, best of luck. If you need any help, as I mentioned, put something in the comments below, send me an email. With that, I'll end this video.